Thank you, Saroja. Good morning, Saroja, my learned senior, Mr. Raja, and Pratima. If I were to drop this cup, I would throw it away. But if the Japanese were to drop this cup, they would follow a simple technique called kintsugi, which involves mending broken items. And they actually make a virtue of that. They embrace their flaws. They mend these broken pieces together with gold or silver. Now, in the context of this Consumer Protection Act, there was a great opportunity after a lot of struggle to actually overhaul this legislation, to do a kintsugi of the Consumer Protection Act. But I am afraid that this opportunity has gone a begging. The twin USPs of this legislation is expeditious disposal and beneficial legislation. We didn't need an act as such for beneficial legislation, a new act, because earlier there was an amendment and they said up to 5 lakh rupees you have no fee to be paid to file a consumer complaint. But it's taken 1 year to come into effect. And till that period, in the interregnum, there was a lot of ambiguity as to whether it would operate prospectively or retrospectively. It's only recently, through a circular inconspicuously hidden, tucked away in the NCDRC website, that an assistant registrar has clarified that it was placed before the president of the NCDRC, and he has clarified that this will come into effect prospectively and not retrospectively, which means if you already have cases pending in the different fora, this district, state, or national commission, they would remain where they are as of the 20th July of this year. So it's taken 1 year. Now, during this period, the number of cases that have really been kept getting adjourned for lack of clarity on the pecuniary jurisdiction aspect. Now, if you look at the statement of objects and reasons of this legislation, admittedly, in the very first paragraph, they say, disposal has not been fast. Disposal has not been fast. So it begs the question, what are the fast track measures in this act? Precious little, I would say almost nil. Mercifully, the Supreme Court recently, this year, in New India Assurance versus Hilly Multipurpose Cold Storage, had very clearly reiterated that there shall be nothing further, nothing more than a 45-day cap on filing a written version. Otherwise, if people would file condemnation of Delhi, and it will go on and on till thy kingdom come. The devil in this act, like most other legislations, lies in the procedures. And the common thread, if you ask me to compare the 1986 Act with this 2019 Act, the common thread between these two is in the form of a joke. And that joke is this 3 to 5 month timeline. 5 months if it requires forensic examination, forensic analysis. Now, please understand the reality. There's a big gap between what is in the law and the practice. It's not just a gap, it's a crater. A single adjournment in the National Consumer Dispute Redressal Commission is on an average 5 to 6 months. A single adjournment. The Act talks about disposal, but I'm talking about a single adjournment, sometimes even beyond 5 months or 6 months. Not surprisingly, recently a Delhi High Court judge did a calculation and he said it will take 464 years to actually clear the entire backlog of cases in India, but not just consumer cases, overall across the country. Today, the Consumer Protection, the NCDRC website says there are about close to 5 lakh consumer cases pending across the country. Why is that? We don't have any statistics to tell us how many cases have been disposed of in this 3 to 5 month statutory timeline. How many cases? I shudder to imagine. I don't think there would be hardly 1 or 2% of the cases. That also, in most of these cases, if their complaint is withdrawn after the parties decide to settle their disputes. Look at the slogan of the Consumer Protection Act. Often it infuriates me. It makes my blood boil as somebody who practices in all the three, in the National Commission, the State Commission, and the District Forum, now called Commission. You have this slogan, Jago Grahak Jago, awake consumer, awake. And they make it so, rosy when you look at the, the advertisements that they put out. A person has to just write a complaint, attach a bill, and presto, he gets justice. It is so cumbersome. Look at the number of procedures. First, you file a complaint, and they say that you don't need an advocate. I mean, I shudder to imagine how many ordinary complainants without the help of advocates will be able to navigate this complex web of procedures that exists. You file a complaint, you file a list of documents, and then the other side has to file a written version. Then if there is a condemnation of delay there, you file a counter to that. Then you mark your documents, you file a proof affidavit. Again, you add all the documents, number them, stitch the bundle, then you file written versions, then you make oral arguments. I mean, the procedure itself is a big turn-off for most consumers. Secondly, another reason for this huge delay is vacancies. You will find a template on the cause list. It's almost become a template today. Lack of quorum, no sitting. I'd like to ask the administrators here, do vacancies come like flash floods that we are not alert enough? Why can't vacancies be filled in before they actually arise? Somebody to take over the baton the moment somebody resigns. Why is that you have to have, even in the new act, there is no mention, not a squeak about filling in vacancies in a timely manner before they actually arise. There's only a provision which talks about ad hoc sitting arrangements, like for instance now in the district Chennai South, after the retirement of the president, the North president is actually holding fort. So on 3 days of the week, you have sittings in the South, and 2 days, of course, now the pandemic, there's no sitting at all. 2 days in the week in the North. So you see how it operates on the ground. Now you have this, the new act, instead of actually remedying the situation, if you look at section 43(2)(b), the new act, it doubles the composition of members in that state commission. You don't have enough. I don't know, for some reason, I refuse to believe that there's a dearth of talent to fill in these vacancies in our country. For some reason, they have doubled the composition of members from 2 to 4 in the state commissions. It defies logic. Then you have adjournments, which is the bane of any legal system across the country, particularly in the consumer fora. Several times you will find the members, the president, telling the lawyers who seek adjournments, last chance, post on this date. That last chance goes on till the cows come home. There is no limit on that last chance. There's no cap on that. At some point, the last chance should become a lost chance, right? So that beyond the point, there's some deterrence. People don't go on taking adjournments. I am dealing with a medical negligence case filed at the NCDRC in 2011. We're now in 2020, 9 years, and it's been pending, and we talk of 3 to 5 months. What a joke that is. Then you have the quality in fact, coming back to this adjournment business, let me give you an example from personal experience. That medical negligence case that I've been telling you, I have traveled to Delhi 5 times for final hearing, matter posted for final hearing 5 times. I spent 7 hours to travel back and forth. And then in less than 10 seconds, the matter is adjourned and the date is given as of some 5 or 6 months later. On one particular occasion, each time you go completely gung-ho to argue your case, you wouldn't believe it, hold your breath. The opposite side counsel said, it was drizzling outside, said, my lord, I have left the bundle in the car, can we have another date? So I explained spontaneously, I brought my clothes from Chennai to the court and he's left his bundle in the car. Adjournment of 8 to 9 months granted. This is how it actually works on the ground, and we need to understand this. Much as people have these rosy slogans and fancy press releases, and this whole act is unveiled with much fanfare, and there are puff pieces written in sections of the media. This is a reality on the ground. Quality of members. Somehow I got the feeling when I read through that there was no judicial qualification, unlike the earlier act, mentioned for the members of the district, state and national commission. No judicial qualification. They virtually left it to executive control. I'm just wondering whether this tampers with the doctrine of separation of powers. My learned senior, Mr. Raja, would be able to throw more light on that. To me, it looks like it's a tampering of the doctrine of separation of powers. Again, talking about the quality of members we have in the various commissions, and I'll give you a shocking example. I was for a complainant before a district forum. One of the grounds of the complaint was suffocation inside an aircraft. The person was made to, the entire family on a holiday were made to board an aircraft 2.5 hours before the actual takeoff. They were refueling. No issue with safety. Obviously, it has to be switched off. But why make passengers board 2.5 hours before the actual takeoff? So one of the grounds in the complaint was suffocation and injury and all that under the old act. After listening to arguments from both sides for an hour at least from both sides, comes a judgment. There's no question of suffocation, because if the AC was switched off, the fans would have been running. You're right. You heard it right. The learned member, the learned president of the forum, thought that there were fans inside an aircraft. The same quote, I am told, there was another case where another lawyer representing an airline company told me that in the issue of miles, like you get reward points, so air tickets, you get miles. So the learned member wanted to know what is the distance between India and America. How many miles? How can this be? There's something wrong there. So he actually thought they were literally the distance. The miles refer to distance. So there's no domain knowledge. I mean, I'm not here to ridicule anyone here. I'm not mentioning names, but there is absolutely a lack of domain knowledge, which is why the role of experts come in. That also has been ambiguous as to what kind of expert opinion can be given. Like for instance, in a case where a car, a luxury sedan, had a brake failure on the highway. The entire family, the last few days, there are no retakes in life. Till the car came to a halt, they must have died a million deaths. Now, the car was towed away to the workshop. Where will I have the opportunity at that point to go and get an expert to think? And the car still remains in the workshop. They refuse to take back the car. They said it's a killer vehicle. We don't want it. So there are these practical issues that the Act could have addressed, but it's fallen short of all that. Now, there are, yes, as Mr. Raja very rightly said, there are some very redeeming features of this new legislation, thanks to efforts of his and several other leading senior jurists, advocates, activists. Mediation, how this will work, I don't know, but that's a welcome sign, because in many cases you find that it's actually ego at play. So if at the very first instance, at the threshold itself, if you can resort to mediation and solve the issue, then you don't need to really go beyond that. So mediation is a welcome feature of this Act. Product liability, yes, for damage suffered because of product liability. Then you've got a pecuniary jurisdiction. I'll come to that later. I know it's started in more detail the latter half of this session. This pecuniary jurisdiction also has a very important change here, extremely significant. It has made a transition from total relief claim to actual compensation paid. That's something that's going to be very, very, very contentious. We'll deal with that later. Then you have electronic filing, again, a very welcome feature. How this will play out, again, remains a big question. Celebrity endorsements. I know the Advertising Standards Council of India has been doing a great job, but then, of course, they really don't have teeth. They're more a regulatory body and they really can't enforce their orders. And as Mr. Raja said, unfair trade contracts. In fact, the Law Commission in a series of reports has flagged this issue about unfair trade, contracts, lopsided contracts, standard form contracts. Today, there's even talk about consent forms when you give before a surgery, which an attendant or which the patient has to sign. Now, you asked me about whether there was a need for the new Act. Personally, I believe, this more than 3 decades old legislation. Personally, I believe there was no need for one. A few strategic amendments would have sufficed. For instance, crime has evolved in our country. Crime has evolved a great deal, but we are still okay with the Indian Penal Code of 1860 vintage, with the Evidence Act of 1872. I always give people this analogy: to arrest bleeding, you can use a cold compress, you can have stitches or perhaps a band-aid, but not always would blood transfusion be required. Amendments would have sufficed after consultations with relevant stakeholders. I think that really is a big lacuna here. They're not really consulting the right people. Relevant stakeholders, those who actually practice in these forums, in these commissions, to actually give you a record. For instance, in Roger Matthew versus Union Bank of India, the Supreme Court had appointed Mr. Arvind Datar, learned senior advocate of the Supreme Court, to go into the functioning of tribunals. And they went into a lot of DRT, debt recovery and debt recovery appellant tribunals, and submitted a report. I think the time has come for us to have a proper fact-finding mission into the functioning of consumer fora in this country. Saroja?
Thank you, Sanjay. Mr. Pinto, my next question is to you. Under the CPA 2019, the pecuniary jurisdiction of consumer fora has been increased. Could you elaborate on this and share your views, please?
Thank you, Saroja. In fact, many months ago, when I was writing my weekly legal column, Justice for All, I, in fact, troubled my learned senior, Mr. N.L. Raja, this point about prospective versus retrospective operation of an enactment. And he very clearly told me that it was settled law, that any procedural law will, unless specified to the contrary, will apply retrospectively. Now, the good news first is that thanks to that circular from the NCDRC, this Act will operate prospectively. So the change in pecuniary jurisdiction will not alter, will not require a mass exodus of cases, a transfer of cases from NCDRC to the State Commission, to the State Commission, to the District Commission. So that's good news, and that's something that we can, thank God for small mercies. Now, for the benefit of those who are not entirely familiar with this change in pecuniary jurisdiction, earlier it was up to 20 lakh in the district forum. Now it is called the district commission and it is up to 1 crore. The state commission earlier it was from 20 lakh to 1 crore. Now it is above 1 crore and up to 10 crore. In the national commission, earlier it was above 1 crore. Now it is above 10 crore. So this is a change. What will this effectively do is that it will make the district commissions bottom heavy. So this whole apparatus will be bottom heavy and top light. Because let's face it, I don't understand the logic. Most of the cases, most of the consumer disputes will be within 1 crore. Even if you have these insurance claims and other, unless they are medical insurance cases, which will go up to more than, sometimes even more than 10 crore, but usually within 10 crore for loss of life. So most of the cases will land up in the district commissions. What is the additional infrastructure that we have in place for the district commissions? As it stands, most of the district commissions, there are vacancies. They don't operate in their full strength. There is lack of quorum, as I said earlier. So this will put added burden to the district commissions. Are we ready for that? Didn't they have enough time to get this in order first? Second question is, since most of these cases are within 1 crore, almost all the cases will land up only in the district commission. So there will be a full 3-tier appeal process. A full 3-tier appeal process. Earlier, you would have only appeals, let's say, if after above a certain threshold, above 20 lakh, it would only be before National Commission and Supreme Court. Now, almost every case in the country will have a 3-tier appeal process, that is the State Commission, the National Commission, and the Supreme Court. This will further delay the process of closure of disputes, disposal of cases, final disposal of cases. Because we do know, while for an ordinary individual consumer, they may kind of give up. Like in that case of that airline where the judge found that there were fans inside the aircraft. The complainant was shocked beyond words and said, I don't want to fight this anymore. What is this consumer thing that you're talking about? Why did you advise me to do this? What a waste of time. And then I actually had to tell him, look, as a matter of principle, I want to fight this case. I'll do it pro bono for you. I'll fight it pro bono for you in the state commission. Now, because there was a little condemnation of delay, they have gone to the NCDRC with a review petition. Okay, so this is one thing. So big corporate houses will fight. They have their retainers, they have their lawyers on a retainer basis. They will fight till the last tier. But for ordinary consumers, how many of them will be willing to go to the state and national commission? Therefore, we need to have circuit benches more frequently of the national commission in various state headquarters. The second thing is this prospective application. We know that the principle that a law looks forward and not back. So the procedural law, as I said, the ambiguity was there earlier. Why didn't they specify it very clearly in the 2019 Act? Because they did not specify it clearly. Because of that ambiguity and lack of clarity. Thousands and thousands of cases in the district on all the three tiers have been indefinitely adjourned, saying for lack of clarity on pecuniary jurisdiction, post after 3 months, post after 5 months. Some of my cases have got adjourned like this for over a year because of this lack of clarity on the pecuniary jurisdiction. Now, at least better late than never, we've got that clarity that it will operate prospectively. Now, a very, very important change, as I had briefly flagged earlier, is the total relief. Earlier, it was under sections of the old Act of the 1986 Act. It was under sections 11, 17, and 21. Pecuniary jurisdiction hinged on total relief claim. There were several decisions of the NCDRC and even Supreme Court which very clearly said total relief claim, which is the costs of goods and services, consideration paid, plus mental agony, plus compensation, plus interest, plus costs. I saw one of the questions about costs. Somebody had raised a very valid question about costs. What about cost of traveling to the commissions for all the hearings, the number of hearings that we have? 33 hearings, 33 adjournments, Saroja said in one of those cases. Now, the problem with this total relief claim now, moving to just consideration paid. I'll give you a simple example. Suppose you purchase medicines from a pharmacy for 500 rupees and they turn out to be spurious. Apart from other legislation, apart from criminal complaints, this is an act in derogation of any other law. So that's an additional remedy. Consumer Protection Act is an additional remedy. So let's say for 500 rupee medicines and I have serious side effects, their health hazards, or perhaps even leads to loss of life, which means in such cases I can only go before the district commission because my total consideration paid is 500 rupees. Loss of life, I may claim 10 crore rupees. I may claim 1 crore rupees. I can't go before the higher forum. So therefore, I am now rooted. I am stranded here only in the district commission. I don't understand the logic behind tampering with this thing. Why do they have to tamper with this? Why can't it be the total relief claim? This is something that is very serious, and I'm sure will be assailed, because if you look at sections 34, 47, and 58, they talk only about total consideration paid. Now, I am reminded of what Lord Halsbury had said in that Medina case. He said, how can you measure pain and suffering in money in monetary terms? How can you possibly do that? The other aspect is costs. I find that it is customary for many, except for certain exceptional cases. I remember in one of my first cases, when I made that lateral entry from TV journalism to law, my first case, some of the people I had covered became my clients, like the newsmakers. There was a international squash champion, Arjuna awardee, Deepika Pallikul, who fought a case. We fought a case against a big bank. And there, of course, that was a case where she swiped a debit card, international debit card. She had more than 10 times the balance available, but the transaction declined. So that was held to be deficiency in service, causing her mental agony. Perhaps for the first time, I think there was a landmark case, they awarded compensation of 5 lakh rupees. So 5 lakh rupees was ordered in that case, but that many say it's because also of media outcry because of insensitive remarks made by the bank and all that. But the point I'm trying to make here is that costs have to be actual costs, not some old Paleolithic kind of perception that cost should really be 2,000 rupees or costs of 1,000 rupees ordered. What are these costs ordered for? Photocopying costs? Look at the kind of procedures that you have, the number of things that you have to file. I mean, you look at the waste of paper I can file. Each case that I pile it up on my table, and the client is aghast the number of signatures they have to put. Photocopying costs for all these 3 stages will be 2,000 rupees. What costs are they talking about? 33 adjournments that Saroja spoke about. How many times a lawyer will have to go? Which lawyer will argue a case for 3 to 5 years for 2,000 rupees? Those are legal costs. Which world are we living in? So I think this is an extremely consumer unfriendly measure. This migration from total relief paid to actual consideration paid is something that should be assailed. And I think this bottom heavy, top light philosophy of this, I don't understand the logic. Maybe to deter consumers are not serious. I do agree that compensation should be for relief and not a bonanza, that people shouldn't do, like the ambulance chasers should be dissuaded. Genuine complaints should be encouraged. But again, unless you factor in this compensation, total compensation and costs and interest, that will be a grave injustice of the consumer movement. Just to take 2 quick points, since I'm within the time limit, Mr. Rajas raised a very valid point about a bad road. I've always been thinking about that. In fact, I keep telling my wife Vidya when we used to drive out before the pandemic, of course, that I pay road tax, lifetime tax. I pay a bulk amount that is also subject to interest. So I am also paying a consideration. So why can't I sue the government, the transport department in the consumer forum? Because the bad road, I've already paid life tax. That goes towards your maintenance of road. That's why it's called road tax, right? Life tax. Why can't that be considered consideration? Secondly, I'm paying a fee. If my complaint now is more than 5 lakh rupees, I'm paying a fee, whatever small fee it is, beneficial legislation. I'm just wondering, it's just a eureka thought. Why is that action should not lie against the consumer forum itself for deficiency in service? Your act says 3 to 5 months. I'm paying a consideration. I'm paying a fee. Why can't a complainant also take the consumer forum to task for a delay, for an inordinate delay? So I feel that, there has to be some kind of pecuniary jurisdiction. Like, for instance, you have the Arbitration and Conciliation Act, Section 34. You have to file an appeal within 30 days, within 45 days. There are specific wordings in that enactment, but not thereafter. Why is that we cannot have but not thereafter when it comes to disposal of cases? Why can't there be some kind of disincentive for members of commissions if they prolong and if they allow adjournments repeatedly? Because even the CPC, the provisions of the Civil Procedure Code, say up to 3 adjournments. We know that's not really practiced. So there has to be some effective cap. I'm glad the Supreme Court took that initiative, but I really wish the Supreme Court had enlarged the scope of its observations. That would have had a more salutary effect on the functioning of consumer consumer commissions in this country. But pecuniary jurisdiction, I'm glad that they have said that it will operate prospectively. But this pegging it and limiting it to only total consideration paid, in my opinion, defines logic. Saroja?
Thank you. Thank you, Sanjay. I'm so happy to hear this. Only if this happens, bringing everyone to books. I hope that happens. Okay, so I said this is going to be a rapid fire round, and the question to you is: Two points that come foremost to your mind when I say this. Success of CPA 2019 lies in.
Single shot filing. Please understand that consumer rights today are flickering like a candle in the wind, and the breeze is picking up. Now, if you look at clause 26(1) of the Consumer Protection Regulations 2005, it says every endeavor should be made to avoid the use of the Civil Procedure Code. Let's only go by principles of natural justice. So why not a single filing procedure, marking documents at the consumer complaint stage itself, then the written version and oral arguments with automatic uploading of
Some,
that's when the 3 to 5 month timeline to be a joke. Saroja?
yeah. Thank you, Sanjay.